Welcome again, friends. Now the next judgment that I'm going to speak today is about Aeropolis Infrastructure Pvt Ltd, Sasnagar, Mohali. Respondent number 2 is Sukham Infrastructure Pvt Ltd. There are multiple complaints, 4 in number, this being disposed by a common order. The date of decision is same, 7th of April 2022. You can see on your screen, I'm just quickly skipping the parties part. Now coming to the order, this is a common order for all these 4 complaints since it involves common question of law and fact. Now the project in question was promoted by the name of Yellowstone Landmark Info City, which was later renamed as Aeropolis City. Now the specifications are something like this. Super built up space measuring 3000 square feet on the ground floor in the industrial IT park, SCO 1860 feet, and plot of 1000 square yards in industrial IT park. This is how they have promoted it. Now sum of rupees this one has been paid in 2009 and 10. A buyer's agreement was entered in November 2010, in which possession was to be given in 3 years but has not been offered. So a follow-up was done. Ultimately, in 2017, under a settlement that was arrived, the following properties were given to the complainants. Base shop, 83.3 square yards, 40 by 36 square yards, 1577 industrial square yards plot. So the respondents took the original agreement back in 2010, and the payment receipts were also taken back, and they issued a fresh receipts of the payment made. However, the possession of the units was not offered to the complainants when they followed up, and the respondent does not have any necessary approvals. So the relief that the complainant has sought in this complaint is that the respondent should deliver and develop the project of all the units cited above, and also should pay the interest from November 2013. So they are taking the previous transaction date as the date of interest. Now coming to the respondent side, in para 3, let us see what they have to say. The reply was filed by the parties, and as per their standard reply, they say there is no cause of action for the complainants to file this case since the maintainability is in question. They are not having a bona fide and it has been filed with the ill motives. Now the respondents, while an order was also given permission to file additional documents, that has been recorded. Now there are 4 complaints. Just coming on to the 1 facts of the complaint. This is this shop that was given to the complaint number 1 and 2. Price of 17.50 lakhs, out of which 17.25 lakhs have been given, and the possession was to be given in 2 years. For the next complaint, the shop is of 36 lakhs, 35 lakhs has been paid, and there was no agreement for sale. Third complaint, similarly 17.75 lakhs, balance amount has to be paid at possession, no agreement for sale. Further, the last plot, same 17 lakhs something has been paid, and rest possession to be given in 2 years. Now let us see what has been argued before the authority in this case. So the complainants still say that they haven't got the possession in this case, and they should be able to get interest from 2013. They say that the very first agreement got signed between the parties in November 2010, and after given a reasonable time period of 3 years, it should be from 2013. Now it has been almost 12 years have been passed that they haven't got the possession of their unit, so they are liable to claim interest. Now the factum of the case is one person has paid all the money for the properties, so they have purchased the properties in name of their close relatives. So they say that the time of the possession has not yet arrived. So there is a difference in between the date of possession in all units Now the respondent is also claiming benefit of the RERA circular, which was issued for extension of projects under the COVID-19 pandemic. So they are claiming a benefit of extension time as well. And also they have argued that since the agreement was later revised and done in 2017, so from that time period the timings may be kindly considered. Now authority coming on to the question of prematureness, that whether the complaints are within the timeline or not, because in some cases the possession has not been delivered as per the agreement, the date has yet to be arrived. So they have given a case law where the definition of premature civil suit has been quoted in the judgment. Again, the ruling has been quoted. These are the civil suits, not the RERA judgments, which have been quoted here. So they are citing the civil law, that what is the prematureness and how it can be overcome by the law. So the relevant part has been quoted from the judgment only. And for further different complaints have been there. There are 4 complaints. For each 4 of them there is a different timeline. So the judgment is quoting them distinctly. That for one lot there are 2 shops. For them, yes, the cause of action has arose. In 2021 the possession has to be given. So these 2 cases are covered. But for rest, the date of possession has yet to be arrived, because if we count 3 years, then it will be September 2022. So this point has been duly noted by the authority in this case. Now coming on to the further additional arguments that were placed, that interest date they are claiming from 2013, but since no agreement is placed of 2010, and as per law, when some later agreement has been signed between the parties, the later will have prevalence, because it will supersede all transactions. So that's a correct position of law. Accordingly, this argument has been dismissed. Now further, the overpayment, like they claim that they have given more payment to the builder, this has not been supported by any claim, any receipt. So this argument has also been ignored by the court or denied. Now further, regarding the amount dispute, the calculation of interest would be difficult, because once the payment receipts are not there in picture, the interest part is difficult for the authority to calculate. Now moreover, they have claimed that the execution of plot number 1578 has been concealed by the complainant. So authority has given them the benefit. Thus, this would not be fatal to their case. On this ground, the case shouldn't be dismissed. So they are giving a benefit to the complainants. So further, the authority in their last para, they are admitting complaints, 2 complaints of 2021, 69 and 73, and they have ordered that the respondent will pay them the interest from February 2022 till a valid offer is made after obtaining completion certificate. And for the other complaints 70 and 72, since the date of possession is yet to arrive, they are termed to be as premature. So they can later on file complaints if there is a delay. So this is the finding of the RERA Regulatory Authority Punjab in the case against Aeropolis and Sukham Infrastructure. So hope I have been able to cover this judgment clearly for you people. You have the understanding of the law now. So do subscribe to my channel for more updates. I'll be encouraged to do more of such kind of judgment digest. And if in case you have any query or questions, you can always visit my website. My contact number is there on the website, and this would help me to answer all your queries. So again, thanks for watching and keep coming back to my channel. Thank you.